Right, good morning, ladies and gentlemen. We're going to make a start. There may be a few people coming in a little bit late, but a very warm welcome to you. Welcome back to those frequent on top of taxes, and particular welcome to those that may be their first time. Just a couple of housekeeping points. Mobile phones, please can you switch them off rather than on mute. We are filming today, so it just plays havoc with the system. We also have a house rule: if the mobile phone does go off, it's £10 to the charity, either to the person of your left or the person of your right's choice. So, action-packed agenda today. In fact, before we go into that, we needed a fire escape routine. We don't have a fire alarm predicted, so if we do, if you could just exit that direction at the back, that would be great. And afterwards, you'll see from the agenda we have Q&A. It's easier if you can save the questions for any of the speakers to the end. We've plenty of time at the end to do questions and answers, and we've got more coffee and tea if you prefer to approach any of the speakers on a more individual basis. That's absolutely fine. We're more than happy to do that. Well, we normally have action-packed agendas. This one is absolutely crammed. We've got 5 speakers, so the less I say, the better, because these ladies and gentlemen here with the things that you came to listen to. But we're very pleased to have Patrick Soares with us from Gray's Inn Tax Chambers. In fact, Patrick will be one of the few people in Gray's Inn Tax Chambers quite soon, because most of the chambers are moving out because it's being refurbished. But Patrick, along with another Patrick and a few other colleagues, will be remaining in Gray's Inn, so he'll be even more famous than he was before. I'm very pleased to welcome Patrick. He's spoken at these on top of taxes before. What I particularly like about Patrick is his clarity of address, and also if you go to Tax Council with him, his ability to take what I feel are very complex problems that we've been wrestling with for several months and just make them appear incredibly simple and overlay on top of that solutions. So I can highly recommend Patrick from a personal perspective. The other speakers, Andy will be picking up hot topics in reward after it's a bit like a horror movie, isn't it, Patrick? The tentacles of tax avoidance. I was kind of going to gloss over that, but what struck me actually on the tube this morning was how topical this issue is. Only this, I think it was yesterday or the day before, the revenue announced that they've collected an extra £24 billion on top of the normal tax take through targeted anti-avoidance, and people in this room represent 1/3 of that. So 1/3 of the 24 billion has been raised from large companies, so particularly topical for Patrick. So then it's hot topics in reward, non-payroll labour by Teresa, international mobility strategy, a bit of a mouthful. Hopefully Andy will make that simpler than it sounds. And then the very topical, we hear a lot about this, country by country reporting. I think there's a lot said about it. However, I think it's not very well understood exactly what country by country reporting requires, when it's coming in, etc., etc. So I will pass swiftly on to Patrick Soares. Thank you, Patrick.
Thank you, Ross. So you've got notes, and in the back, I've got notes with diagrams and some detail. So if you can actually turn to those, and if you want to, we just go through that as I go through my various topics. So let's see if this works. Yeah. So the tentacles of tax avoidance. And what I'm basically going to be talking about is if you do some tax mitigation or avoidance planning, what can the revenue do to you, basically, is what we're looking at. And also whether there's anything you can do in return. That's, in a nutshell, in a fairly concise way, is what I'm going to try to do today. And this is essentially, if you look at it, I'm going to look at the way the revenue rams you and the Ramsey doctrine. There are specific anti-avoidance provisions which you need to look at, and there's the GAR. And those three are called the three-headed hound from hell, Cerebus. And then there's the disclosure provisions, which you have to tell the revenue if you're doing any tax avoidance. There's these new promoter provisions in the finance bill. There's the public view. There's what they say in Parliament, what the judges will rudely say to you if you do tax avoidance. Then there are a few things you can do in return, like judicial review. EU comes to the rescue, believe it or not, because it overrides all that lot. So that's the Orpheus in the underworld, you see, puts Cerebus to sleep. And then there's a few interesting cases where people have tried to use human rights to try to defend their position. The cases on human rights haven't been terribly successful. I think in the notes that the last one was where a taxpayer said it was enforced labour to try to complete a tax return within Article 4 of the Human Rights Act. He got a hearing, but he didn't succeed. So there are things you can try, but essentially, what is the position? If you do a tax avoidance plan, someone comes in and they want to do tax avoidance, what do you actually have to say and what do you go through? And that's really what it is. But if you look at page 3 of the notes, it all started 33 years ago when the taxpayers were able to look at things literally. And there was an article by a barrister called Blom Cooper who said, look, the courts have got to come out with a bold stroke to stop this. He did an article in the British Tax Review, and the bold stroke came fairly quickly after in the form of Ramsey. And if you look at page 5 of the notes, Ramsey, there's cases, 33 years of cases, and the question is, how do you distill all those cases, a lot of which sort of contradict each other, none of which have been repealed by former decisions, and how do you distill that? The client comes in and they say, does Ramsey apply to my particular transaction? I'm doing A, B, and C. For example, one I had recently was a company with clogged losses, transferred an asset making a gain to an individual who then wanted to sell on straight away to a stranger to make use of the losses. How does Ramsey apply to that? And do you go through the 33 years of cases? Well, what I've done on page 5 is I've tried to put Ramsey into a form which is like a statute. If you were to apply Ramsey, all those cases, and put it into a statute, what would it come down to? Quite recently, the courts have said it comes down to subsection 1 of these notes. It is the driving principle in interpreting a tax statute is to construe the relevant statutory provisions purposefully and view the facts realistically. And you look at the footnotes at the end of that, gives you all the cases as to where that conclusion comes from. So really, Ramsey, after all 33 years in the wilderness, has come back to saying, well, I'm going to look at the facts realistically. So if you did that transaction I just gave of transferring out an asset to a person having made losses, who then sells them to a stranger, so you make use of the clogged losses, you look at the facts realistically, well, you're going to sell to a stranger. Look at the legislation, it's supposed to allow losses only if you transfer to the particular individual. Therefore, we can cut that out, we can tax you, and you can't make use of the losses. So that, in a way, is a summary of 33 years of cases, none of which are repealed and all of which are supposed to state the law. You've gone right back to that very sort of simple principle. And if you look at page 7, there's the summary of the cases which back up that statutory provision. And so really what you essentially did when Ramsey first came out, you had what was looked at as there's a taxometer, actually a taxometer, which I sort of keep on my wall to see where we are presently on this scale of literal tax provision. I read the legislation, I apply the legislation. No nonsense, you don't do that anymore. When you look at the substance of the position, Where is the taxometer? Well, remember the Duke of Westminster used to be very literal. Now it's moved over. A case called Black Nominees was Templeman, who said, I'm going to start looking at the substance. Started all moving. Furness and Dawson, hundreds of other cases. Now we're off the scales. If you look at page 9, the Scandinavian jurists, they call it the digestive school. They say you don't study the law anymore, you see what the judge has had for breakfast, and if he comes in a bad mood, you're in dead trouble. You actually study the judge, you don't study the law anymore. And if you look at page 9, there are two cases looking at the same section called Mays and Astill. And in the case of Mays, the taxpayer did a perfectly legitimate arrangement creating a capital loss out of nothing. That's perfectly right. And the court said, well, you created a capital loss out of nothing, you don't get a deduction. And then later on, the same provision came up with same judges, case called Astill, and they said, well, we don't think you should look at the substance of this. We think Parliament intended you to look at this literally, and therefore the scheme succeeded. So that's why the Scandinavians say, look, it's what the judge had for breakfast. It depends on what judges you get. And the first thing you see when you go to if you're taking a tax case, you say, what's my chances of getting this judge or that judge? So really you're in a very difficult position on the taxometer, that you're off the scales, so anything goes when they want to look at the substance. And essentially what I'm going to be looking at then is, in a moment, is the three-headed hound from hell is Ramsey, which we've just looked at, i.e. the court saying, well, ignore the words, I'm just going to look at the substance. You've got specific anti-avoidance provisions, which I'll just touch on briefly. Then you've got the GAR, which I'll touch on a little bit more with a case study showing where its weaknesses are. But you've got to look at it. If you can overcome all that, then of course you've then got to live with the fact that private eye may pick you up, the press, Hodge may pick you up. If you go to the courts, the judges may strip you down and cut you up. But basically, it's worth trying getting over that hill, the three hounds from hell. But so what will the revenue do first? They'll first probably not go for Ramsey. They may go for, on page 10 of the notes, a targeted provision. So normally when you've got a tax provision, there's an anti-avoidance provision on the side. These are basically three types. There's one which is a very weak type, which says that if you do something and you just create an artificial loss or a deduction for interest, then you don't get it. It's a very weak anti-avoidance provision. It catches only very circular transactions. There's a middle ground, which is a Willoughby type anti-avoidance provision. And then recently, there's the worst I've ever seen. If you look at page 11, if you're trying to avoid the new partnership provisions by saying that you're making your partners, salaried partners, not salaried partners, because there's now legislation saying if you're a salaried partner, you're deemed to be to be an employed person. If you try to overcome these provisions by ensuring that your salaried partners become real partners, the anti-avoidance provision states in page 11, this states that in determining whether a partner is self-employed, no regard is to be had to any arrangement, the main purpose of which, or one of the main purposes of which, is to secure that the partner is self-employed. So that is quite difficult to avoid a provision like that. So that's about as bad as you get on the GAR, the TAR. And if you look at this, there's like a Richter scale on these specific anti-avoidance provisions. You have a look at them. As I say, the worst is the one I've just mentioned, where it's very difficult to avoid them. There's some which go off the scale. Some of them are zero, so they're so easy to avoid. And what are those? Those are provisions which are so wide in their effect that the courts have struck them down. Those anti-avoidance provisions are lovely to see. They come in once every 50 years. The old section 720 was so wide it caught everybody. Caught everyone in this room, for example. Now, the court said the section doesn't catch anybody. So there you are. So that's the second thing you need to look at. The third thing is the general anti-avoidance provision, which I'm going to just take a case study to see how it applies. And this is the GAR, general anti-avoidance provision. I just take this example. Got an overseas landowner, parent company. It wants to sell the property to a subsidiary because the value has gone up enormously in value, and it wants to increase the amount of interest relief which it gets from the rent. So P has rented out property, it's got an old borrowing, small amount of interest relief against the rent, wants to sell it at present market value, subject to transfer pricing, to the subsidiary, and it borrows into group. Will you get a deduction for the increased interest against the rent? So that looks like a bit of planning, a bit of tax planning. Does it offend the GAR, the general anti-avoidance provision? Does anyone want to guess before we look through whether you think it offends the general anti-avoidance provision? Do you think it does, or? No, okay, it doesn't. Oh, well, I could take away my big selling point then. Okay, let's have a look at, very quickly through the GAR, how it applies. You first need to be confident that the basic plan works, that you can get a deduction for the interest against the rent, and you can pay the interest gross. No difficulty on that. If you look through the notes, that sort of legislation's fairly straightforward. Page 12 of the notes, you'll get a deduction. Now, the GAR, which is the general anti-abuse rule, essentially states that if you do something for tax avoidance purposes, and what you do is abusive, then the arrangement is just and reasonably modified. It doesn't make things worse than what you started with, but it takes away the tax advantage you've tried to achieve. So the question is, would you consider that to be abusive? That's the question. And on page 15, in determining whether something is abusive, you look to see whether, in substance, the result of what you're doing is contrary to what Parliament intended. Does it go against the policy or intention of the legislation? That's the first thing you have to say. Then you say, is that contrived or abnormal? Is it contrived or abnormal? If it is, if you're in trouble, you're in trouble. Are you trying to exploit a weakness in the legislation? If you do, once again, you're in trouble. There's a few things which indicate that you're in trouble, and that one of them is if you do things which don't change things, which result in a tax advantage, but don't change the position economically. So that is an indication that you're going to be caught by the GAR. They're all taken into account. Without a change in the economic position. Okay, so you have to decide whether you personally, because that's what the judge will say, whether he personally considers that to be contrived or abnormal. Is it contrary to the legislation? Are you making use of a gap in the legislation? In which case, you can see that they can take away your advantage in a just and reasonable fashion. There's one, however, not weakness, but point in the GAR which you should know about on page 16 of the notes, and that is revenue practice. The revenue have had practices over the years. You can take into account their practices in determining whether something is abusive. Okay, so very important sentence in all this, because I think this is one of the things which takes away the sting of the GAR and enables one to say really it shouldn't be a dramatic change in the position. So if you look at page 16 in the middle, they accept that you must take into account their practices. The nature of HMRC's acceptance may be relevant. This is the revenue, the panel. For example, the acceptance may take the form of a statement to the effect that HMR considers certain practices fall within the scope of the particular provision, but they have an accepting they grudgingly accept that it works. They say you don't add a lot of weight to that sort of agreement by the revenue in the past, or even now, if they grudgingly accept things based on the old law. They grudgingly accept before the GAR came in that you don't add a lot of weight to it. But if they have a public statement and they've written to you and they say, yeah, we accept it under the old law before this new rules came in, then that is taken into account in determining whether the GAR applies. So old statements, and I'll show an example of how this works, you take into account to see what your client's got on the file, what their public statements are, to see what the revenue did with your particular arrangement before the GAR came in, even though the GAR wasn't in existence in the past. And I'll show how that comes into effect. But essentially also remember the GAR doesn't affect the Ramsey Doctrine or any of those TAR, those specific anti-avoidance provisions, so it adds on top of them. So you've got all three adding on top. So basically, how would I, applying all that to this transaction, does it succeed? Would you not say this is abnormal and a contrivance? Could you say it's an abnormal thing? Bearing in mind that you haven't affected the economic position of the group as a result of this, you've just got interest relief out of nothing, even within a sale within the group. And so I would probably be worried if I was looking at that, just applying the legislation as it stood under the grounds of abnormal transaction. But critically, though, this is an area which the revenue have commented on in the past, because there is a stamp duty land tax provision which says that if you do that with a view to trying to avoid income tax, stamp duty land tax or capital gains tax, then you don't get stamp duty land tax relief, even if you try to avoid income tax. And the revenue have gone out of their way in the past to say this is not avoiding income tax because it's a natural thing to do, whatever their reasons are. They think, well, providing the land has genuinely gone up in value, we don't think that's offends the old stamp duty land tax provision. So they've got a public statement stating what view they have on that. That view states they don't think it avoids income tax, hence you get the stamp duty land tax relief. And that comes in any arguments on the GAR, that comes in. So I'm very confident that this arrangement under the GAR provisions would not offend the GAR, and providing you stick to market value, you'll get the relief. Okay, so that's one example. There are thousands of examples which you can go through, but don't forget that little one of seeing, well, what have the revenue said about this in the past, because that can have quite a big bearing on what the position is. Okay, so far I've said the clients come in and you said, right, okay, we take into account those three things, and what other things can the revenue do to me if I do any tax planning? Well, the next one is on page 23, and this is quite interesting. It's the disclosure requirements. The moment you come up with something clever in tax, you've got to tell the revenue within 5 minutes, within 5 days, and they'll decide whether to close it. They normally close it in the following finance bill. I had one client who's quite well known, and he was doing one of these arrangements where essentially what all the tax planning schemes were, I put out £100, I borrow with non-recourse finance, and I get tax relief on £1,000. That's basically all the planning schemes were and are. And the scheme, which was basically a capital allowance scheme, was disclosed to the revenue. And the moment he knew that he would get a tax avoidance number, because you actually get a number for your scheme, he imagined himself on television with striped pajamas and his number, prison number X on his name, and that was the end of it. He wouldn't touch it with a barge pole. So don't forget the disclosure requirement provisions, where you may have to disclose your provision, and that is another tentacle of the Inland Revenue. It's the fifth one, isn't it, that you have to tell them straight away. They've got all these arguments against you, and they've got the ability to say, well, haven't you disclosed this? You've got a legal obligation disclose what you've said. The other one is bit of armoury which the revenue have got is the new provisions in the finance bill which require tax to be paid up front for people promoting schemes to provide the revenue with information. Otherwise, they get a bad conduct notice served on them, and they can be required to reveal even more information. You've got also, if you look at that page, the Law Society of England and Wales not liking stamp duty land tax schemes and warning solicitors that they've got to make sure that they're doing things which are proper, frightening a lot of solicitors off from being involved in the arrangements. There are still, in passing, there are a few stamp duty land tax plans left. I've got to mention those. One, if you're buying residential property, the stamp duty charge, generally in the case of an individual, 7%. This is just an apropos, you see. But if you purchase, along with the residential property, a small commercial property, like a slice of your accountant's interest in their property, for example, so a purchaser buys mixed residential and commercial, then the duty is 4%. Okay, it's quite meagre, but you can actually reduce your charge. I've got to tell you that, just to show that there's something left, basically. The other thing which is quite interesting, if you own a company and you want to buy the property out, if you as the individual are in partnership with your company, you can buy the property out without paying stamp duty land tax under the partnership rules, because it's as if your company had transferred the property out to you, and the company is one of the partners, and you're connected with the company, so you don't pay stamp duty land tax. The last one I've got to say, just so I get back on the revenue on this, is that if you actually have let property in partnership, you can roll it into a company, or even sell it into a company, which you control without paying stamp duty land tax. Those are just minor things which have survived the devastation of stamp duty land tax. But otherwise, it's a hot area, and as I say, solicitors are very nervous that they do a stamp duty planning arrangement, whether they come in under some major criticism, and they get no sympathy from the Law Society. So that's the next thing. The other thing on page 25 is if you've managed to overcome all the problems, don't forget the newspaper, Private Eye. Is there anyone from Private Eye here sort of televising this? We are being televised. And then does it get on that? Do you come before the newspapers? You look at the bottom of page 25, the icebreaker, the revenue one of those arrangements where you basically put in 100 and you get allowances on 300. They don't stop making their point. HMRC made publicity straight away. When they won the Iceberger, they stated on their website, Iceberger tax avoidance crushed. We will not tolerate abuse of the system by people trying to dodge their tax obligations. They lay themselves open to penalties and potential prosecution. So it's a hostile environment is the other point. And in one case which I structures, I have to come back to myself on this one, case called Tower Cashback, which basically involved investors buying intellectual property, and then it's one of those where they laid out 100 and hoped to get allowances on a greater amount, 3 or 4 times the amount, and the monies were deposited with the bank, and then fees, and then the intellectual property was exploited. And the idea was that if the exploitation was correct, they would end up paying up all the borrowed monies, but it ended up that the arrangement wasn't a great success. But what I did in that case was I made sure I follow word by word followed an earlier Court of Appeal, House of Lords decision in setting up the structure. And it was appealed, one in the High Court, one in the Court of Appeal, came to the Supreme Court, and for the first time they decided to have a full court instead of 5 judges, 7, getting ready to overturn their earlier decision. In the end, they managed to find a way not to overturn it, so I didn't win. But the Ramsey approach was the key thing. But what it does mean is, if they don't really like your scheme, they'll overturn their old decisions, just have a go at you. So old decisions, old interpretations of the law, old cases, if you look at it, they're all potentially being knocked aside. And this new thinking, this new Ramsey thinking coming in, and they're saying, well, we consider this was a circular transaction and you didn't get your allowances. So the highest court is willing to overturn its own decisions to cause arrangements to fail. The other thing on page 26, don't forget, another point is the revenue have a very deep purse. I don't know if you've been involved in any arguments with them, but they remind you that they have a very deep purse and that you must be willing to lose all your money. Page 27 of the notes, this is where you counteract, and that is these Ramsey approaches in the GAR don't overturn the EU law in the area. And if you can manage to make use of an EU law provision, then you're okay. And the good example of this is section 720 of the Taxes Act about transfer of assets abroad, where the legislation says if you transfer assets abroad, in this particular case it was taxpayer transferred assets to a Liechtenstein company, interest arise and was paid to a Stiftung. The revenue say, 720, the Taxes Act, we've got you. But that's subject to EU law. So let's take a simple case. If that was to Malta or something, you'd say, no, section is overridden by EU law. EU law says you only get taxed on the income of an overseas company unless there's a nameplate or a nominee company out there. If it's got some sort of substance, then you're okay. And the UK government's wrestled with this, trying to make it compliant with the EU law. In the end, they gave up and they said the section only applies to the extent that it's compliant with EU law, which is great. They couldn't resist adding, providing it's also a genuine commercial transaction, which is again contrary to EU law. So the point is, if you've got cases where you can see that EU law override, such as this one, why this is okay is that Liechtenstein is now in EFTA, is in EFTA, and the EU laws generally apply to EFTA, but the European courts have restricted that because they've said, well, there isn't the same disclosure of information within EFTA as there is for the EU. There's now a treaty with Liechtenstein, so there may be the same level of disclosure. So it may be that now, for all relevant purposes, Liechtenstein can be treated as part of the EU for the purposes of overriding these sections. So the key thing is that things like the GAR, Section 720, the focused anti-avoidance provisions won't help the revenue when it comes to EU law. And quite interesting, look at bottom page 27. Europe, the French in particular, have an abuse of rights system, which if you try to avoid tax by literally interpreting legislation, that system says I look to the substance, and it's called the abuse of rights. And if you look at the definition of that concept on page 27, it is actually very similar to the GAR and Ramsey. And it's quite interesting, it's called the abuse of rights, and the GAR is the abuse. It's called the abuse anti-avoidance provision. So maybe that was part of its origin, and it also fits in with Europe a bit more comfortably. OECD is the one where, quite interesting, a recent battle with revenue over, on page 28 of the notes, over the OECD, that they were trying to adjust the payments by an English company to an overseas company. and they just wanted, they really were saying, well, look, that overseas company gets they wanted to look at the global income and take a slice of it. But they can't, because under the OECD explanatory notes and guidance, they just can't do it. I'm sure if it was all UK, they would have done it, and the courts would have approved it. But they couldn't, and in the end, they had to deal with the fact that they, get comparables, the CUP system, to end up with what was there. But so that's another area where they're stopped in their shoes. Another area on page 29 is judicial review. If they're abusing you, then apply for judicial review. Basically, if they've said something which is reasonable for you to expect them to follow, then they're required to follow that. Mansford and Jelly, an appeal which I've got on. Anyone who wants to join in the appeal, let me know. You've got to have a very clear-cut case. It's a case of losses before you can succeed. If you can't afford judicial review because they're very expensive, then try the adjudicator, because they're supposed to be equivalent to the poor man's judicial review. And you put it all to them, 93% of the cases the revenue follow. So if you're in a judicial review situation, always think, well, can I go to the adjudicator? Because that should, in theory, have the same results. Then page 30, human rights. That was, as I say, quite difficult. That's my enforced slavery case called Murat. Is it enforced slavery to fill in a tax return? I'm afraid that didn't get very far. So what then are the conclusions on the tentacles of anti-avoidance when you're looking at some way of avoiding tax? What are the conclusions? We know what the main line of revenue tax are. It's going to be those three. And Ramsey can now be put into a very simple sentence: look at the substance of the facts and look at the purpose in the legislation, look back and see whether you're going against that. The GAR, I think, will be used as a last resort, because there's a lot of paraphernalia you've got to go before a tribunal, and I'm not sure how often it's going to be used, if at all, but I think they'll use Ramsey instead. They're used to it. And the judges like Ramsey because they created it. They can't criticise it. Whereas a GAR provision, they may be able to criticise. The revenue are very trigger happy because they can use publicity against you, and they have very deep pockets, and they will tell you about their deep pockets and that you haven't got deep pockets. EU comes to the rescue. Professor Wheatcroft used to say that a tax system breathes through its loopholes. He's dead now. Nobody quite knew what it meant, but it was quite. I think he was trying to say that if you close every loophole, then do you actually create a corrupt system? Will people start looking for corrupt ways? But I don't think that's the case. I think what I've actually said, what I've come across is situations where taxpayers, especially with NIC and PAYE planning, they're saying, well, if nobody can do it, I'm okay. I'm only worried if someone else can do it and I can't. And I've got to say that is a sort of an important conceptual thinking behind some of this. Also, it's made us respectable. The GAR has made us respectable. If you look at the last one paragraph, since 2003, if someone says to you at a cocktail party, are you a tax planner? Are you doing all this sort of stuff? You say, no, all I can do is something which is agreed by the revenue or which is reasonably reasonable. That's all I can do. You must be respectable if you can say that. So I think tax planners are coming from the cold. The other point is, has all this anti-avoidance stuff gone too far, which was one of the points which was put to me. I think probably not in this present environment. In the present environment, I think you have to put up with all of it. But if the economy gets better and the revenues start abusing some of these powerful rights they've got, I think the courts will start taking them away and cutting them down. So that's the ultimate answer to the question, has tax avoidance gone too far? And if you look at page 32, there's an exam test. Don't look at the answers, for you to look on the train back and see whether you passed can answer those 10 questions. Okay, good, bang on time. We can now pass over to the serious fellow. So, just leave you on. Yeah.
I did think that was a bit light. I do think we need to get into the detail a bit now. Just to vary it, I will try and refrain from the use of section numbers and tax cases, which obviously I could use all the way through, but I'll try and avoid it. I don't think there's anything in here that, broadly speaking, will hit the scale of most of the things that Patrick was talking about. Interesting point at the end there around the way that people look at pay-as-you-earn and national insurance, and if no one else can get a low rate, then I don't mind paying the high rate. But if everyone else can get the low rate, then I want the low rate. Some of the things in here are talking about how you can manage pay-as-you-earn and national insurance and capital gains exposures. So I think probably that's how this links in. But hopefully, maybe this is a Q&A point, but hopefully points around the GAR and points around disclosure, I'm hoping Patrick won't be raising any eyebrows. I think this is all reasonably reasonable. Hot topics and rewards. So this is about how you pay and incentivise staff. And it has broad meanings depending on the type of company, the type of people, whether we're talking about founders of a business, whether we're talking about new recruits, but generally how people in a business are incentivised to take the business to where the owners want it to go in line with its strategy, whether that be a transaction, whether that just be growth, and ultimately how they are rewarded for doing that. There's a huge amount that this area covers, much of which I'm sure you will be familiar with. I've got a relatively short slot here, so I'm looking to talk about what I've called hot topics. So these are things that are kind of new in the market or that are very topical that people are coming to talk to me about all the time. I haven't got anything in here on HMRC standard approved plans, EMI schemes, CSOPs, SIPs, SAYE. They are all still out there if you guys have come across those, and they're still very popular, but they don't fit into my hot topics slides. It's safe to say that there are lots of businesses that have gone through the last 5 years, which has been a difficult time for everyone, where companies have made promises to people or they've made policy decisions to say we are going to introduce something, we are going to do something, but on the basis of making sure that the business survives, they haven't actually got round to doing anything, and now they're saying, oh, actually, the business is growing, we could be coming up to some kind of event soon, and actually we need to implement some of the things that we've promised. So this is, there are lots of conversations around, okay, well, we've made this broad promise, but how do we implement it now? And that comes down to strategy. What's the right thing to do before we talk about tax? And then how do we deliver it to people tax efficiently? So probably the most hot topic, the thing that people are talking about in and around tax efficiency for incentive schemes in this area, employee shareholder status is top of the list. Now, I don't do hands because that's slightly embarrassing, but are there any knowing nods of people who say, yeah, I know all about employee shareholder status, I've come across this? Not a huge number. So this is something that came in through the effectively the 2013 budget, or it came in through the 2013 budget. It was announced somewhat before that, and it actually applied from September 2013. And it's effectively a George Osborne project that's known as Shares for Rights. So the thing that it made a lot of publicity for at the outset was, is this guy actually asking people to waive their statutory employment rights? So the way it was portrayed in the press is that this guy has come out with a scheme to try and grow the economy by asking the general workforce to forego statutory protections that they've got. And that's what I think was in his mind. The way that it works is if employees of a business are willing to waive some statutory protections, and the key ones here are unfair dismissal and redundancy payments. Some other ones are, I mean, they're in the slide here, short notice to return from maternity or paternity leave, the right to demand work-based training, and the right to demand flexible working. If employees are willing to forego those statutory rights, then they can receive shares in the business that are subject to a specific tax regime. And the key element of that tax regime is that the shares they've got are free from capital gains tax. So potentially they get equity that gives them a 28% saving based on the normal rate, or if they would otherwise qualify for entrepreneurs relief, a 10% saving. And the way that this has gone is that people have said, I'm never going to give out equity to my broad base of staff, to my shop floor workers, and ask them to forego their statutory employment rights, because that would be an HR disaster for me. People would think it's, that I'm a terrible employer. But what it has caused is that senior people in a business have said, I don't particularly value these statutory employment rights. Actually, I've got other rights in my contract, which is absolutely fine, but these statutory employment rights actually they're capped in terms of value. So the most valuable one is the unfair dismissal right, which is a £75,000 statutory maximum. Now, if I've got somebody who I'm going to give him 10% of my business, and we think we're going to sell it for 10 million quid in a few years' time, he's thinking in terms of, actually, I could be saving £100,000 or £280,000, depending on what his capital gains tax rate is. And he is willing to forego those rights with a view to what the tax saving might be. And lots of people are saying that tax saving that's really attractive, and therefore I'm willing to forego those rights to get my shares. So it's causing a lot of interest from people. There's no question that one of the points that gets raised again and again and again is, this looks too good to be true. I think it is, but it is real. So there is no contrived avoidance here. If we go back to the things that Patrick was talking about, these rules are what they are. They will change at some point. I don't think they will change retrospectively, because we're going into an arrangement where someone has waived employment rights with a view to falling within a tax regime, and I don't think you could say, oh well, actually that tax regime now looks too good, we're going to change that. So if and when either there is enough pressure on Mr. Osborne, or more likely we get a new government, this won't be around forever. But at the moment, it's absolutely there. Rules around value: the shares that you get must be worth at least £2,000, but you can only get no more than £50,000 that fall within this regime. And the shares are not tax-free on acquisition, but they are tax-free on disposal. So still, you've got issues around how you get the shares into the individual's hands. But if the value is low, then there might be a small amount of tax to pay. And again, we're looking at how much money we can make when we sell them. And so this type of arrangement is often combined with something called growth shares or flowering shares. So the concept of a growth share is that we get a piece of equity into someone's hands so that we could, for example, get it under the employee shareholder status. But it is a specific class of share that only takes the value over and above a hurdle. And there are two reasons that you would do that. One is a commercial one, to say, actually, we've brought this person in, we've built the value in the business to where we are today. So we're not just going to give that away to him because that value has been built by the kind of legacy staff. But actually, we're going to give him the value, the share in the growth. And so conceptually and commercially, a growth share may look like an attractive thing to give. From a tax perspective, a growth share is obviously going to be worth less than a real share. And then you come back to, okay, so I can get up to £50,000 worth of these shares under my employee shareholder status. So the tax may well marry up with the commercials. I can get you these shares. The amount of tax to pay at the outset is relatively small, and then I get you into tax-free growth. This graph here shows, you can see something called the hurdle. So if I was talking to you about this maybe 5 or 6 years ago, my hurdle line there would be the same line as the dotted line, which is my share price at the date of award. And then I would be saying that the difference between the two is effectively the economic value that would go to the growth share. Now, HMRC have not attacked the tax rules here, and they've not attacked the arrangement. But what they have said, that if you get a share where as soon as we start to add value to the business, the individual gets a share of that growth, then actually that growth share must have some value. Even if we sold the business today, he wouldn't get anything, because there's some hope value in there. And so the way that you would create a growth share today would be that you would say, The growth share takes the value over and above the hurdle, and the hurdle would be probably a compounded level of growth of the business, which you might say is the expected level of growth. And then if we outperform that, such that in my graph here, the share price is above my hurdle rate, that's the value that you get for the growth share. So again, I think that growth shares, they are seen as a tax-driven incentive mechanism, but actually commercially, they tick a lot of boxes. A similar concept is the flowering share. So what this says is that I create a new class of share where the rights of those shares are minimal unless and until we hit a corporate target. And if we hit that corporate target, then those shares will effectively flower in value, and they will then become worth the same amount as an ordinary share. But today, that share won't be worth nothing because there is an expectation that we might reach that target and we might hit the ordinary share price. But if it's a stretching enough target, the value of a share today is going to be relatively low, such that I can get it within my £50,000 ESS limit. And yet, if the individual performs, or if the company performs under his leadership, then he will end up with value equivalent to an ordinary share, and he can make a lot of money out of it. And again, if we go into the ESS structure, that will be tax-free. Transactions. So there's a lot more deals going on, people selling businesses, people doing MBOs. There are a whole load of issues that people need to think about. They need to think about them early. If you want, so ESS may not be appropriate for everybody, and you may not be able to get into it, but that takes you to then looking at entrepreneurs relief. Entrepreneurs relief, if you want to be able to claim that at the time of a deal, you need to have had your equity, and you need to have effectively had met the conditions for a year before the deal. And then most transactions are not as simple as we're buying your shares off you for cash. There will be potentially, you're going to get some equity under the deal, you're going to get some loan notes, you might have an earn-out, that might pay out in a number of years' time. And the answer from most people's perspective is, if I'm in ESS, how do I get my 0% on everything I make? And if I'm in entrepreneurs relief, how do I get my 10% on everything I make, given that potentially I have to stay around in a new structure? And so they are really key considerations, and the earlier you plan for them, the better. But ultimately, there's a ton of things to think about in terms of getting that piece right. And then income tax on transactions. People always think of transactions in terms of capital gains tax, but income tax is always there in the background. So that could be income tax through distribution. So HMRC have historically always been wise to the idea of people putting in effectively steps into a transaction that make it look like a capital gain, but actually I've got a load of cash in my pocket, but I still own equity in the business, and they will often, or they've certainly got plenty of anti-avoidance in place to recategorise those, what look like capital gains, as dividends. So I'm sitting there thinking I've got 10%, actually the revenue come along and say it's 31%. And then there's employment income. So there is a real blurring of what is an incentive, because getting equity can act as an incentive, and what is capital. And when you're talking about earnouts, but also if you're talking about redistributing consideration, all sorts of things that do often come up on deals, there is a risk that people are sitting there thinking 0% or 10%, and then we're not even saying 31%, suddenly we're talking about 47%. So these are things that you need to think about, and the earlier that you can think about them, the more opportunity there is to plan for them. And then IPOs. IPOs I'm as busy as I've ever been talking to clients about listing. And there are a huge amount of things to think about around there. So existing share schemes, existing incentive structures, what happens to those? Do they roll into the new business? Do we exercise and people cash out? If people exercise and cash out, what are we going to do in the new business? If people have got EMI, can we roll that up and keep EMI in the new business so they're looking at effectively a 10% tax rate, or do we lose all the benefits of our EMI and our approved plans? Those issues are very complex, and as a kind of the common theme is here, the earlier you think about them, the better. And then there is what do we do with people's packages if we go from being a private business to a listed business? So in the private business, we may have been much more comfortable doing tax planning. We may have said, well, actually, this person's package, salary and bonus can be relatively low because he's working towards a sale of the business. Now we've IPO'd, that's not the same. And suddenly, is there a bigger threat of us losing our key people? And do we need to benchmark that kind of thing? So that's less tax driven. That's more just about getting things right for the business going forward. And then there is a whole new world of reporting that a listed business has to go through. And fully listed businesses, whether you're newly listed or whether you've been listed for years, but fully listed businesses have got a whole new regime on how to report remuneration for directors. And that is a big headache. Lots of people are getting their heads around that. And so that is something else that people need to think about. You need to have a policy that shareholders approve. So remuneration for listed businesses becomes a whole lot more serious. You have to have forethought it and get things approved by shareholders. So they are my hot topics. Teresa is next.
Good morning. I've got about 15 minutes, or as of this morning, I had 13 minutes, but we've been given an extra 2 minutes, so I'm not quite sure how to contain my excitement, to alert you to some of the changes in the area of non-payroll labour, and we'll come on to what that actually means in a minute. So lots of changes that have been happening, from the 6th of April. Some of them were well flagged and some of them weren't, so we're all kind of in a bit of a state, what does it actually mean? And no doubt watch this space. So, what is non-payroll labour? Well, it won't surprise you to learn that this is any category of worker that you as the engager don't pay via the payroll and subject to tax and NIC through the usual deductions. So typically this might be agency workers, it might be casual workers not on the payroll. It's very old-fashioned to talk about being paid off payroll through petty cash, but it still happens. We have self-employed individuals that are not in a limited company. And then we have workers engaged via a personal service company, including, for example, non-executive directors, which is a really hot topic at the moment, or an LLP, or any other entity. And so this is basically anyone that is getting some money via you that is not subject to deductions through payroll of tax and NIC. So why has the revenue suddenly got an interest in this area? Well, this gives you a bit of context. There's around 4.4 million self-employed individuals in the UK. And the revenue have got it in their heads that this area is completely rife with non-compliance. And I suspect there is, areas of non-compliance like there are in most sectors, but they really have got their head set in this. And there's numerous structures, to use their phrase, to engage the services in individuals, especially in certain sectors. So you'll all be familiar with the IT. I think they are well known for operating in this way, not non-compliantly, just operating through personal service companies, etc. So the revenue came out last year and said that they were going to do some stuff to really focus on this area. And they produced two consultative documents. The first one was well flagged about offshore agencies, which we all knew about. And both that one and the one that we didn't know about, which was announced just before Christmas with a very short consultative period around onshore agencies, it was prefaced by two things really. One was the concern for the poor workers. And that they were concerned that people were forced into these structures by unscrupulous agencies or anyone else, and they were missing out on employment rights, etc. And I have to say, I'm not sure I believe that in terms of where the revenue's interest is. Just call me sceptical. And the other area that they talked a lot about was making a level playing field for people operating in this space in terms of providing workers sort of resource. So they talked a lot about that. And so they also talked a lot about, to use their phraseology, false self-employment. So there's a bit of a theme here. So we then get to the last two bullet points, which in my view is the real reason that they're looking at this area. If you looked at what the revenue collected last year, it was 470 billion, and 55% of that was pay-as-you-earn and NIC collected through RTI. So there's a really good cash flow advantage for HMRC here. So I don't know that it's concern for workers. I think it's more concern about increasing the Treasury's cash flow. So if you've got a lot of money that they would like to collect via RTI, guess where they're going to put their non-compliance activities? Yeah, collecting stuff through RTI. And you don't have to just be a member of Take That to engage in these non-compliance activities. So what are they doing, or what have they done? Well, we've got a whole raft of new legislation from the 6th of April. Some of it was rushed in, particularly about onshore agencies. There's a lot of concern in that sector about what does it mean, particularly as there's penalties and reporting obligations as well. So there's quite a lot of pushback to try and get some further clarity, but they went ahead, and even though it's in the finance bill, so it's not actually law yet, it is effective from the 6th of April. So there's quite a lot of concern. People wanted them to defer it, but they weren't having any of it. So the use of self-employed individuals, if you have been doing employment tax as long as I have, which is only a couple of months, of course, this is something that they've always had a massive interest in. They feel that people don't understand the rules. Again, they're trying to look at the employment status. In any good employer compliance inspection, this is a very easy area for them to look at and to make some recoveries. So that's always been the case. If we look at the onshore agency, this is a new rule from the 6th of April. And broadly, and I'm making this very simple because otherwise you'd all go to sleep. Broadly, this makes the UK agency closest to the end client responsible for pay-as-you-earn NIC, unless no person in the contractual chain has supervision, direction or control on the worker. And as I said before, there's penalties and there's reporting requirements. And so I'm keeping this at very high level just to see how you may be affected and then maybe what you need to do at the stage if you are affected. So what they're trying to do is stitch somebody up with the pay-as-you-earn NIC liability if it doesn't exist already. The only get out is if there is no supervision, direction and control in that contractual chain. So that means it's not just the agency that should be looking at that. It's kind of the end client. It is anybody else in the chain as well, because some of these resource providing mechanisms are immensely complicated. So offshore agencies, so broadly again, this passes the pay-as-you-earn and NIC liability to the onshore intermediary that's closest to the end client. If there isn't an onshore intermediary, then the end client, i.e. the person that's using the worker, is responsible for pay-as-you-earn and NIC. The LLP structures Philip mentioned earlier, which is, whilst this is all to do with non-payroll labour, but this is kind of focusing, again, it's in from the 6th of April, this is focusing on if you were a member of an LLP, there was a presumption up until the 6th of April that you were self-employed. That presumption no longer exists, and there's lots of complicated rules, as Philip was indicating, as to whether or not you should be treated as an employee for the purposes of pay-as-you-earn and NIC, if, for example, you're a salaried partner, and there's definitions of what that means. But I've lumped it in there because it's all part of the same thing. What do they want? They want money. They want it on a regular basis. They don't want to have to argue about where it's coming from. Again, sort of following on from Philip's talk this morning, there is a specific targeted anti-avoidance rule in this space, which basically says if the purpose or one of the purposes is to avoid the agency legislation, we can disregard it and we'll put it in there. So there's getting a real theme about what are you doing? If we don't like it, we can overrule it. again, I've tried to keep this really high level because you could be sat there going, I'm not an agency, why do I care? So I've tried to split it into what you might fall into. So you might be an end client, so I'm sure most of you in this room, if you're working for a large corporate, part of that large corporate will need staff and will need resources. And one of the ways that you get resources is to use agencies. One of the ways is that you might engage contractors directly. I was talking to a client yesterday, feeding back on an exercise that we had done on all of their contractors. And we categorised it red, amber and green. And they had 15 people in the red category, which is where we felt that there wasn't sufficient information to decide whether they were genuinely self-employed. And over just a 1 year period, that was 1.5 million. And it was a relatively small corporate. They had the big issue here is that there's no visibility within organisations about what you have. And we'll come back onto that. So are you an end client? Probably. You might be an agency. You might be an offshore agency. You might be an onshore agency, and I held a breakfast briefing for some agencies specifically 3 weeks ago, and there's a lot of concern in that sector. You may be an intermediary. You might not know you're an intermediary, and that's the point we're going to come to because it's quite widely defined, and you might be a worker. So what does it mean? And I say this is just a very high level. If you are the client, if you use an offshore personal service company or an agency, then the pay-as-you-earn and NIC liability could end up with you. So that's kind of quite a bold statement. And I say the problem that most of my clients have got is that there is no visibility. So the reason that there's hardly any visibility over this, in your average corporate, you have HR, you have finance, you have tax, potentially, if they've got in-house tax team, and you have a payroll department, which usually is outsourced in some kind of way. You have lots of people involved in taking on resource and paying that resource, but you probably haven't got one person that has direct responsibility for employment tax. So there is a huge lack of responsibility, as in nobody's got clear sight over it. And secondly, if you've got a large, devolved, complex organisation, let's face it, you go out and you get resource because you need things doing. If you need a hole dug in the road, you go out and you get a labourer to dig the hole in the road. If you need an IT consultant, you go out and get an IT. And the business is out doing what the business does. And if you're sat in the centre from a finance point of view going, excuse me, I need to know the status of this person, it doesn't go down too well. So just at a purely commercial level, if somebody in your supply chain is having to pick up some additional pay-as-you-earn and NIC, the employer's NIC is 13.8%. Guess where they're going to be trying to pass that? Somewhere along the line to you as the end client or somewhere else. If you're a large corporate with a turnover over 200 million, you fall into the senior accounting officer regime. This has been running for 3 years, and what we're finding is it's a bit like I was talking about earlier, who's got line of sight. So you may have an individual that has to sign off to say that the tax processes and procedures are robust enough to give everybody confidence in what the end results look like. But where we're finding it falls down is most people spend an awful lot of time and energy getting their corporate tax bit right. They've probably got in-house teams or they use advisors. The same with VAT. Most people know that they need somebody to look at VAT or they buy in the advice. Employment tax is the area that people are finding the most issue with. And for the very fact I mentioned about whose responsibility is it, how many people are involved, who's got oversight. So all of a sudden, as the end client, things are starting to appear on your horizon. HMRC interest, we've already said, hugely interested in this area. If they're hugely interested in this area, they are going to be doing much more non-compliant activity. Guess where they're going? Corporates. It's easy money. They are having to put together budget and recovery plans to show that where they put their resource, what is going to be the outcome for the Treasury and HMRC, and guess where they're going to focus. At a much more commercial level, it may mean that you struggle to access the right specialist and resource. And that's a very high-level view, but you can see there's stuff out there. Some of it's financial, some of it is risk, and some of it is a commercial reality that you might need to struggle with. So hopefully you're now thinking, I might need to think of what this means to me. If you're an agency, margins tend to be pretty tight if you're running an agency. If you're now going to have to pick up extra costs, it's going to erode your margins. And those extra costs might not directly relate to pay-as-you-earn and NIC. We've already talked about that you can fall outside of this legislation if the worker has no supervision, direction or control. But if you've got a branch network of people taking on workers, do you have to train them to pick that up? Do they know what that means? Do they have to cover right across all of the sectors? So it might not be hardcore pay-as-you-earn and NIC, but there's admin that you need to think about and build into your processes and procedures, because there is a need for an audit trail and some evidence if you are not deducting pay-as-you-earn and NIC. Why is that? And there's reporting requirements that come in so that you need to report those people not under deduction of pay-as-you-earn and NIC to the revenue. And equally, guess what the revenue are going to do? They're going to focus on the names and addresses you've given them as those guys not under deduction of tax. So it's, I hate to say it, but it's quite a neat way that the revenue have tackled this to find out and really get their hands around what they perceive as a real problem. If these workers now become your employees, you suddenly fall into things like national minimum wage, auto-enrolment, things that you may have never had to think about before. You have got clients. The clients, if they've got the head screwed on, and probably after this high-level view, is they'll go back and go, so how are you dealing with this? What does our contract say? Whose responsibility is this? And can we have a look at what we do with you? So you've got to manage those client concerns, because you'll get more and more questions. And then finally, agencies have over the years developed a way of potentially using expenses via the means of a dispensation, which improves their margins and means that they can pay their workers a bit more if they do it compliantly, and even more so if they do it non-compliantly. The revenue have said in the next year they will be reviewing the travel and subsistence rules yet again. So they're really having a go at the agencies to try and drive them all down the employee route. So, intermediary. I mentioned earlier that the legislation is quite widely drawn, and basically it's defined as any company sitting between the client and the worker. So we have got a couple of examples recently where somewhere in the supply chain, you can fall into being an intermediary, and therefore you can fall into potentially the pay-as-you-earn and NIC issue, and you can also fall into the reporting issue. So the two examples we've had recently is we've got a very, very large group of companies. One of those companies in the group actually procure resource on behalf of all of the other group companies. Do they fall in? We think they do. The other one is involved in the provision of workers, and that's because, again, it's a very wide definition and it's been purposely drafted that way. And we had a particular example where actually they are involved with the organisations that use the workers, but in a sort of non-contractual way. But because of the way that the legislation is currently drafted, and hopefully will not change before it comes out and gets royal assent in July, they fall in as well. So it's quite widely drawn, and you may get drawn into the damn thing without even intending to do. So if I'm a worker, what am I worried about here? Well, it's absolutely the issue here is more and more it's going to be workers in the past have sometimes shrugged their shoulders and went, I just signed up, it's your problem, you sort out the pay-as-you-earn and NIC. But more and more the worker is actually getting embroiled in what the right tax and NIC position should be. So how do you provide your services? Are they compliant? Do you know how you're being taken to these end clients? Because particularly if you've got offshore, typically Australia, New Zealand, some of the European resources that work in the UK on a regular basis, they don't know the rules, they sign on a piece of paper and they just want to work here. You no longer can have that blind, oh, it was fine, I signed a bit of paper, they said it was okay. What may I be asked to provide? So increasingly, I think we're going to see more and more indemnity clauses in terms of what the worker is covering the end client or even the agency for. There's a question about whether you'd want to legally enforce any of those indemnity clauses, but I think we're going to see the use of those more and more often. Again, HMRC interest, what we've seen an increase in is the revenue going to the workers and going, so tell me how you work, who do you think you're employed by, how does that, who pays your tax, where do you claim your expenses? So there's a lot of interest in the individuals, and they may be trying to pass their pay-as-you-earn and NIC liability further up the chain, but in some cases you could be on the hook as well. And if I really am genuinely self-employed, I'm going to have to help people understand why that is and help them through the reporting requirements and help them through managing the whole of the process. So you could be potentially affected in any of those ways, all the way down that supply chain. It's really complicated. I've kept it really high level because if I started talking about Section 44, you'd lose the will to live and you would very quickly start to get into, well, what does that mean and how does that look? There is a very new section, those of you that want to look at the HMRC's manuals, in the Employment Status Manual, there is their latest thinking on all of this stuff and what it means, and there's some really, I was going to say really good examples, but there's some examples in there about supervision, direction and control. So if you have responsibility for this area or you need to have a look at it, that is a really good place to start. I keep coming back to, do you have visibility over the relevant area? Do you know who's working with you? In this review I was reporting back yesterday, of the 40 people we looked at, 20 of them didn't have any documentation in place. I mean, that's just poor. So we're starting to look at process, we're starting to look at standard documentation, we're starting to look at process maps, and again, if you're a large corporate, all of that feeds into your SAO regime. And I keep coming back to, the revenue are really interested in this area, they love to look at it because it gives them lots of money. And things change, and what I mean by that is, we had a fabulous example, which I will finish on, which we were doing this similar review for a very large conglomerate, and we were going through who was doing what, and there was a little guy who was a lorry driver, and he'd been there 26 years. He turned up Monday to Friday, 9 to 5. He filed his staff expenses with everybody else, but he was still self-employed. So things change over time. So if you think that you've got control of it now, then you need to flag in 12 months' time what has changed, because the revenue will. So I will turn you over to Mr. Bailey now.
Good morning. Teresa talked about resources, and Andy talked about employee strategy and reward. So I was asked to talk about international mobility strategy. So what is international mobility strategy? It's when you start to move people around the world. So it could be someone moving from country A to B because you have a business there, or because you want to set up a business there, or because you want them to come and work in your particular country. So why is it important? Well, it's a very large investment. When you start moving people around from one country to another, there is a big cost. It is believed that the cost is somewhere between 2 to 5 times the cost of employing a local. So big investment, and bear in mind also the investment in the person is but part of the overall investment. What you would also be doing is seeking what are they trying to achieve whilst they are there. So the project investment could be much larger than just the cost of moving someone from A to B. And always what you should be thinking is, well, what are we as a business trying to achieve? So if we're moving someone, is it just because they want to go there, because their partner's there, or is there a particular aim of the business? And the sort of typical moves that we see, I've broken them down into 4 parts, but they can blur across the different individual parts. So one is where the big empire is trying to keep an overview of what's happening out in the regions. Darth Vader gets pitches up to see what you're actually doing, try to install a bit of corporate culture, corporate oversight on you, some leadership perhaps, someone to come and give direction to the business. So someone fairly high level who is going to take a leading role in driving that particular business forward. It could be that someone is needed, and this is more usually the most common one, particular skill. So a particular expertise that you need someone to be in a location. It could be for a particular project, and projects go on from phase 1 to phase 2. It could be for a number of years to get a business up and running before you pass it over to local-based staff. Also, quite often what we see is companies want to give individual employees an understanding about working in business or an understanding of the business in which they work. So individuals, sometimes newly qualified graduates joining a company for the first time, may be sent out on developmental assignments, and typically these are 3 months, 6 months. So just a rotation around different countries to get a broader understanding of the business. Often see it with larger companies. And the last one, request personal. We often see this, the person's other half is going off on an assignment with their employer and they say, well, I'd like to go. Or I've never visited London, I'd like to come and live in London for 6 months. Will you pay for me as my employer? And I did come across one employer the other day who was actually doing exactly that and then complaining about housing costs in London and how expensive they were. It's like, why? Anyway. And this one here, this one chart just shows some of the illustrative costs just to give a flavour. It's actually at the bottom of page 11 if you can't see it, although it's quite small on page 11 of the notes. So when you have a local, you're paying their salary, maybe you're providing a benefit, a car benefit. And, if we keep salaries the same across all, it just helps to illustrate the point. And the total cost of a local is 11, just the salary in their car. But then an assignee, you want someone to go perhaps to Angola. So you're sending an assignee who's single off to Angola. Housing isn't that common, or good housing or equivalent housing isn't that common in Angola. So housing costs are quite expensive. It's not exactly the best location. So the assignees managed to argue that they should get a hardship payment. Of course, everything they want to buy, Heinz tomato ketchup, is a bit more expensive in Angola, so they need a bit more money for that. And also because it's a hardship location, they want to come back a few more times, or they want to go off to Joburg and Cape Town and stay there. So next thing you know, their cost has almost doubled. Now, assignee B then comes along and they say, well, look, I've got a couple of children. So, of course, my housing is going to be more expensive and you're going to pay for that. And my cost of living is more expensive because I've got a whole family coming with me. And I've got my car and I need to come back home. And, oh, by the way, the schools aren't good enough. So I need some private education for my family. And you say, yes, OK, we need you there for this particular project, and your cost accumulates. When you've got 4 children, arguably that person argues for even more. And then you get the cherry picker. So when you don't have an international mobility strategy, they're just very good at understanding who's got what in the past. So what you have paid out. Maybe they know someone in HR who's told them, when someone went to this particular country, we gave them this level of housing. We gave them a house with a garden 3-4 bedrooms, and that may have been a Signee C house, but the cherry picker says, well, I want that. And they argue that wherever they're going, it's a bit cold in winter, so they want a hardship payment. And this goes on, and before you know what's happened, they've built the best of the best packages. And unsurprisingly, that is the most expensive type of assignee. You will find that expatriates around the world talk. They talk to each other within the company, and they talk to the person they meet in the bar or on the tram or on the bus, and they work out the best of the best package. They will only ever tell the employer about the good things that others get, that they do not get, and that they should get. So an international mobility strategy is aimed at providing a framework. It's a policy. It's basically setting out, we, the employer, may want to send people from A to B from time to time. This is how we propose to do it. Here are some broad level principles. And the broad level principles could be things like, where possible, we will keep you employed in your home country. Where possible, we'll keep you in the home country employment pension scheme. We'll keep you in the social security system in the home country if we can. Maybe we'll put you in the local bonus scheme. So it's just setting out, this is how we will approach assignees and assignments. It's giving a benchmark. So do you get a container of a certain size? What's short term? What's long term? When do the short term become long term? And what happens if someone's in a location for 3 years, 4 years, 5 years? At what point do you start to curtail provision of housing, cost of living allowance, education allowance? And if you don't put those things in at the front, it's very hard to take them away from someone 3-4 years down the line. Most important thing about a policy is having one that's fit for purpose. So quite often we'll be asked by our clients, surely you must have done a policy for someone before, just give us a copy, take out the names, give us a copy. That is the most pointless thing to do, apart from giving away someone else's intellectual property and confidential information. If the policy does not fit the culture of the organisation and does not fit the business strategy of the organisation, people will not use it. And if people don't use the policy, then you get back to the slide before where people start cherry picking what they want. And HR then don't find out about people moving from A to B. So get a policy that is fit for purpose. Have one that is flexible, that can adapt to changing circumstances, and update it periodically, because as the business changes, your policy will need changing at periodic intervals. And for those of you working in HR, retain control of the policy. Do not let the employee dictate to you, the employer, how the policy is determined and who has the final say. So my top tips on international mobility strategy and designing a policy is make sure that it aligns to the business strategy of the firm, update it, decide on the company's approach. So here it's variables, so like high touch. Certain employees, certain companies want to help their employees more. Others say, well, actually, do you know what? You're quite sophisticated. You can just go online. You can look up what the policies are online. You don't need to talk to anyone. It's very light touch. Some will insist on an IT solution only. And some companies, if you talk to them about an IT solution only, and they said our CEO or CFO will never go online. They want a face-to-face meeting across this table. They will not be filling in data booklets online. It's your policy. Get one that is fit for your company. And you can vary it, so you can tier it depending on the level of the person. Use technology to best effect. I mentioned earlier, 2 to 5 times the cost of a local hire for sending someone. It is amazing how many companies do not do a cost projection when they're sending someone to undertake an assignment. Small upfront cost, this is what it will be to the business, the investment for the business, this is how much it will cost. You will see many going on the internet and Googling what tax rates might be in another country and trying to determine what the final numbers will be. And invariably the final numbers only come in, a year, 18 months after the event, once all the final tax returns are done. So, use technology where it's there, take advantage of it, and manage the data. There's a huge amount of data in terms of employee costs, employee benefits in country A, B, perhaps a third country. How do you bring that all together? And then how can you actually use that data far more efficiently? So the next trend could be, how do we measure our return on investment? Never seen one yet on a good one on mobility strategy. Patrick talked earlier about compliance. Companies are really concerned about being caught out by private eye, the press. It's not just Starbucks, Amazon, Google and corporate tax. If the CEO wasn't paying their tax in the host country, it could be very bad news for the employer and the company. And managing the risks, very, very important. The days of going to Asia and Africa and just deciding not to pay tax there are well and truly over. So much information is shared between countries these days. And lastly, invest in your team, people who work in your team, and also your partner. We're here to help you. So others like us are here to help you through that. So thank you. Now to Paul.
Okay, good morning everyone. 15 minutes on country by country reporting. Conscious that I'm standing in between you and coffee and the rest of your busy day. So I'll try to keep it concise. Happy to field questions as we go through, or we have a slot as well at the end. So I'm a transfer pricing specialist, and it's been very interesting times for transfer pricing recently. So when I look around the room, and again on the knowing nod basis, is everyone familiar with transfer pricing? Lots of knowing nods, okay. Has everyone got a uniform and fully comprehensive documentation package supporting their transfer pricing? Okay, not as many nods. Okay, well, I'll talk to you a little bit about where we're seeing some of the developments in transfer pricing. And one of the biggest developments of recent history, I think, is on country-by-country reporting. So I'm going to do three things today. Just talk about, what is country-by-country reporting and give you some of the context. I think the context is really important here. So then drill into the specific requirements and issues that we're seeing that will potentially come with country-by-country reporting, and then to talk about the implications and what it is that you can be doing as of now. So, what is country-by-country reporting? It's really one of the key first deliverables out of the OECD's base erosion and profit shifting programme. So BEPS, as we inevitably shorten it to, is really the response to a lot of the media and government focus on transfer pricing and international tax principles generally, and media pressure being in many forms, but I think some of the most recent and high profile are the Parliamentary Accounts Committee hearings for Google, Amazon, Starbucks in the US, Senate hearings and equivalent. So CAT was the latest one in the firing line. And for, I think, a confluence of factors, there's now real political will that the international tax system as a whole be rebooted, be overhauled. There's a feeling that many of the principles were set in a different era, and the globalization of business, the advent of more sophisticated communication, has meant that business and the way that business has done has outpaced the tax principles that has attempted to fairly attribute profit and taxation rights across countries. So the BEPS programme is set around three themes. So ensuring coherence internationally, and something that we've heard a bit of this morning, restoring the full effects and benefits of international standards through the realignment of taxation and substance. And if there's one word that I think sums up the BEPS programme, it is substance. It's the attempt to realign back to where the real creation of economic value is happening. The third theme is ensuring transparency. and promoting increased certainty and predictability. So country by country reporting, and I've highlighted some of the actions that covers country by country reporting as an aim at least, with action 13 being the specific one. So country by country reporting is very much the attempt to set out a clear basis for tax authorities to understand the transfer pricing map, if you like, for multinational groups, to enable them to then make better risk-assessed judgments as to where they are going to focus their efforts. So BEPS as a timeline is very aggressive. And this has got a lot of political motivation behind it. The OECD feel that they cannot deviate from what are incredibly tight timelines. And September 2014 is the first big batch of deliverables. And addressing transfer pricing documentation and country by country reporting is in that first batch. So this is just around the corner. So what is it then, specifically? Well, if we look at what the OECD objectives are, threefold. So transfer pricing compliance is more straightforward, more consistent. Same time providing administrations with more focused and useful information for risk assessments and audits. And the overarching consideration is the balance of the usefulness of data to the tax administrations with the increased compliance burden that will inevitably present for taxpayers. So that's the context. What the OECD have done within this context and as part of BEPS is released a discussion draft on transfer pricing documentation. And that discussion draft, which came out at the end of January of this year, had two main components. So the first being, we need a standardized basis of documentation. So let's adopt the master file, local file structure, which has been around as a concept for some time, and the EU Joint Transfer Pricing Forum have set out a basis that if EU-based territories follow, then you're in pretty good shape. So the OECD have adopted that and said, yeah, that's a good idea, but let's expand on that and make it universal. The second and perhaps more contentious part of that consultation was around a country-by-country reporting template. So something that all multinational groups would be required to fill, be you large or small, to give tax authorities that map of your transfer pricing arrangements. So this was an annex to that consultation document. There's some very small writing there, so I'll help you with some of those. But the original consultation was, okay, let's have every entity within a group fill out a row on this matrix. So if you're a large multinational group, you may have many hundreds of entities, so that in itself is no mean feat. But when you then start looking at the types of information and how that joins together, it starts to really build a picture of complexity. So from left to right, entities, place of effective management, important business activities for which there would be specific codes that you would enter, revenues, EBIT, income tax paid to the country of origin and to other countries, withholding tax, share capital and accumulated earnings, number of employees, employee expense, intangible assets other than cash, and then royalties, interest and service fees, both paid and received. So that is a significant amount of additional information, and I think a significant amount of potential system rework to actually get hold of the data, even before then establishing, well, what does all of that mean? How interested will a tax authority be in me? So that went out for consultation, and I think it's fair to say that the OECD were consulted with, and Joe Andrus, who's the head of the transfer pricing unit, positioned this subsequent to that response, as this was a document designed to stimulate feedback, and boy, did it have that effect. So the OECD received 183 responses from businesses, from professional advisors, more than twice as much as any other consultation as part of the BEPS programme, 1,400 pages of public comments across a range of themes, but one of those really key themes is this is going to be incredibly difficult. This is going to create an undue compliance burden. So the OECD listened and said, okay, we hear you. And they've provided a couple of updates via webcasts, and none of this is final yet. We're expecting it to be finalised shortly. The OECD released an update a couple of days back which said, okay, yeah, we've heard you. We've made some changes, and I'll talk about those in a moment. We're going to finalise the document shortly. It's then going to be approved by the OECD, and hey, we're in good time for September 2014 for this to all come about in reality. So in response to the consultation, we've moved away from entity by entity more to country by country. So a key point, I think, is the elimination of the transactional reporting, so the royalty interest, service fees to and from each territory. We will be looking at country-level financial data rather than entity-level financial data, but we will retain reporting of activity measures, so employees being the key one. And as we've shifted away from entity-by-entity transactional reporting, instead we'll have a list of the entities within a territory, and again a specific notification of the types of activity that they undertake. One of the key points that went out of consultation is how do you get the data? And there are two ways. So the first is bottom up. So you start with the local statutory results of each of the entity and build up the picture from there. The second is top down. So right, okay, well, a group will often gather consolidated information, and so you use that and then allocate out as necessary to get to an entity by entity view. The initial leanings of the OECD was bottom up, because that's a better alignment with the local statutory results and tax returns that will be filed in keeping with that. An overwhelming response from businesses, that's going to be really difficult. So the OECD have softened a little bit there and said, well, it's okay, you can do either way, but you need to be consistent from year to year and across territories. So if you go back to the template, what does that consultation have the effect of? So you strike out transaction by transaction, then you put the focus on country. Nevertheless, I think that still represents a very significant additional compliance burden for taxpayers, and this will be applied, as it's currently envisaged, to all groups with an international presence. So no SME exclusion, although that will be down to individual tax authorities to determine, but the OECD steer was SMEs as well. So there's the current status and something that really just trotted through. It's a continuing process, it's not yet final, but substantively it is now set. We will expect shortly, per the OECD's term, the final documents, and when that will actually go live, we're not yet clear, but it will certainly be part of the September 14 deliverable set under BEPS. So what does that mean? I think it's indicative of changing expectations, tax authorities. There's a much higher expectation now of transparency and of granularity in the information that you will be providing. There has been over past years, and this will only accentuate, a focus on the implementation of your transfer pricing policies. And country by country reporting itself is process driven. There will be a process that will need to be established and then run every year. So what does that mean for you now? And there's a couple of bullets up there with some thoughts, but I think it boils down to two things. So one, how am I going to get that information? And each of you will have a different configuration of systems. Each of you will have a different organisation structure as to who's responsible for what in terms of the data. I suspect it will be unlikely that it will be a very easy fit potentially with what you have at the moment. The second is then, well, if I can get the data, what does it mean? What do the results tell me? If I have a territory which has 2% of my employees and 98% of my profits, do you think that is something that a tax authority might be interested in? And this is really designed to flush out, to create the map of your transfer pricing, so you will be giving tax authorities across your group full visibility of all of the arrangements across the group as a whole. And from a transfer pricing perspective, that is very significant, and that is a very marked difference from what we see today. So I think in summary, it's a really big change. It's around the corner, and we're advising people to look ahead and start thinking about it now, because we don't know how quickly the deadlines will fall into place when this is announced, but given the amount of work required to meet those, it's likely that it's going to be a bit of a dash. So I think starting sooner rather than later is probably a good thing. Okay, so I think we're into the Q&A session as a whole.
Well, I hope you'll agree there was at least something for everybody there, probably more than something for most people. We do have, as Paul says, a few minutes for Q&A, or if people would rather approach on a more personal level, we've still got some time in the system over coffee. Just while you're maybe thinking of any questions you might have, just to remind you of the inevitable groan feedback form. But the more you tell us about what you want to hear, the more we're able to deliver what it is you want to hear. So that would be gratefully appreciated. So if there are any questions, old-fashioned hands up. Gentleman at the back, there's a mic just about to appear over your shoulder.
Exciting, good. I just wanted to ask, actually, does an employer have any right to ask a self-employed person working for them for some sort of written confirmation that they have, in fact, captured all their taxes properly?
There's no formal okay, so at least I can sit down. There's no formal right, so you haven't got anything that I could point to in the tax legislation that says that, of course, as an employer you have, or an engager, I should say, rather than an employer, should be able to ask this. But, you know, if you are looking to take somebody on, they want that work, then there is a reasonable expectation that they could provide some information for you. The trouble is that there's no, in the old days, they had a self-employment reference number. That's long gone, and everybody, whether they're employed or self-employed, will have a similar reference number. But there's things you can ask for in terms of, you know, are they registered at Companies House? Have they got a VAT reference number? You know, so it's not unreasonable to ask those questions, is the long answer.
Any more questions? No? If we're all done, I think there's probably a huge amount of content there to go away and cogitate. And certainly the thought of a tax system breathing through its loopholes is going to keep me awake at night, probably, Patrick. Thank you for that. But if I could just ask you to thank the speakers in the usual manner, it would be much appreciated. Thank you for coming.